All right, class, settle down. Settle down, please. Today, we are completely dismantling question number 29 from your previous year's KSLU question papers. Our explainer today tackles the following prompt. Distinguish Hiba and Wakf. Explain the right of preemption. I expect absolute silence and complete focus right now. What I'm about to give you today is not just a standard lecture. It is the ultimate blueprint for drafting a flawless, perfect 16-mark answer in your upcoming property law exam. So take out your notebooks and your pens. We're beginning now. Look at the board. I want you to memorize this exact agenda. This right here is the true anatomy of a 16-mark answer. We have 1. Introduction. 2. Meaning of Hiba and Wakf. 3. Differences table. 4. Meaning and nature of Shufa. 5. Essentials and loss of right. And 6. Landmark case laws. Your KSU evaluator demands this precise structure, so absolutely do not deviate from it. Let's proceed.
Heading number 1. Introduction.
On your exam paper, you'll align your introduction heading exactly to the left margin and underline it once. Your text must read exactly this. Under Muslim law, Hiba, in brackets gift, and Wakf, in brackets charitable dedication, are modes of property transfer. The right of preemption, in brackets Shufa, protects from strangers. Now, pens down for a second. Why do we write it exactly this way? Well, by deliberately dissecting and combining these 3 distinct concepts, Hiba, Wakf, and Shufa, right in the opening paragraph, you immediately signal to the examiner that you possess a comprehensive, bird's-eye view of Muslim property law. You are setting the stage, you see. You're showing them you understand the complete legal landscape before we even get into the granular details.
Moving on. Part 1. Distinction between Hiba and Wakf. You will divide the body of your answer into 2 distinct parts based on the question's demands. In your answer script, you need to write Part 1, Distinction between Hiba and Wakf, in clear block letters, right in the center of the page. This establishes the rigorous, structured layout that evaluators are actively looking for. Now, let's look at the core definitions. Hiba, immediate and unconditional transfer of property without consideration. Wakf, permanent dedication of property for religious or charitable purposes. Listen very carefully to my emphasis on the key terms here. For Hiba, the absolute focal point is the word unconditional. Without that word, your definition is legally hollow. It means nothing. For Wakf, the paramount word is permanent. The KSLU evaluator will scan your paragraph exclusively for these 2 words. If they see unconditional and permanent, they know for sure that you understand the true essence of the law.
Now, we reach the crux of Part 1. You must draw this exact grid on your answer script. Use a ruler. Do not be sloppy about this. Let's walk through the structural comparison row by row. First, nature. Hiba is a transfer of ownership, whereas Wakf is a dedication for God or charity. Second, purpose. Hiba is for personal benefit, but Wakf is for religious or charitable benefit. Third, revocability. Hiba can actually be revoked in certain cases, but Wakf is generally irrevocable. Fourth, ownership. In Hiba, it transfers directly to the donee. In Wakf, it vests in God. Fifth, beneficiary. Hiba targets a specific person, Wakf targets the public or a religious purpose. And finally, duration. Hiba is an immediate transfer, while Wakf is a permanent dedication. Presenting this in a clean 6-row table guarantees maximum marks because it visually demonstrates utmost clarity of thought to the examiner.
Next up, Part 2, Right of Preemption, Shufa.
So leave 2 lines blank after your table. Then direct your examiner to the second half of the question. Write Part 2, Right of Preemption. And always write the Arabic term Shufa right next to it in brackets. It shows academic rigor and a deep respect for the source law. It's defined as the right of a person to purchase property in preference to others when it is sold. It is a right of substitution, not ownership. Let me fiercely dissect this second sentence for you because it's absolutely crucial. Right of substitution, not ownership. This is the foundational legal mechanism of Shufa. The preemptor doesn't magically become the owner upon demanding the property. No, they simply step into the shoes of the original buyer. They substitute the buyer under the exact same terms. If you fail to write this exact phrase on your paper, you fundamentally fail to explain preemption.
Moving on to the nature of Shufa. Shufa is considered a weak right, and it must be strictly exercised. Here is a strict exam tip for you. When you write weak right on your paper, I want you to heavily underline it. Why? Because it is critically relevant to how the courts interpret preemption claims. The law doesn't favor Shufa because it acts as a restraint on the free alienation and transfer of property. Therefore, the courts will actively look for any legal excuse to defeat it. That is exactly why the text says it must be strictly exercised.
Next heading, who can claim? Number 1, co-sharer or sharak. Number 2, participator in amenities like a right-of-way or water. Number 3, neighbor, meaning the adjacent owner. And please note the bottom line, order of preference applies. Let me warn you right now, if you mix up this strict hierarchical order on your exam, you are going to lose marks immediately. The co-sharer always has the first primary right. Only if they decline does the right move to the participator in amenities, and only then to the neighbor. Do not alter this sequence under any circumstances.
What are the essentials for a valid claim? Well, there must be a valid sale of immovable property, the preemptor must have an existing right, and they must make you formal demand, written in brackets as talabs. I want to pause deliberately on this term right here, talabs. A formal demand under Muslim law is not just a casual phone call or a polite request to your neighbor, absolutely not. It is a highly specific, multi-stage, time-sensitive declaration. Without the strictly correct performance of the talabs, the right of Shufa is extinguished instantly. Make absolutely sure you use the word talabs on your answer script.
Consequently, we must explain when this right is actually lost. It's lost by waiver or consent, by delay in demand, by a defective talab, or if the transfer is not by sale, such as a gift or inheritance. I strongly advise you to use a distinct bulleted list format here on your exam. Think about it. Your KSLU examiners have hundreds of papers to check in a single day. Make grading easy for them. Bullet points ensure they see immediately that you have explicitly covered all 4 legal grounds of loss.
Number 4. Landmark case laws.
Let me speak to you with absolute gravity here. Omitting case laws in a 16-mark law question is pure academic suicide. You cannot merely explain the theory, you must substantiate your arguments with judicial precedent. We will discuss 2 paramount cases today. First case is Abdul Qadir versus Salima. This case explained the contractual nature of Muslim law transactions, which is heavily relevant to Hiba. Let's look at the brief background. The facts involve the courts deeply examining whether transactions under Muslim law are purely sacraments or civil contracts. The final ratio decidendi, the verdict of the court, explicitly declared this contractual nature. Now, the absolute relevance of this case to our specific topic today is that it completely validates the contractual aspects of Hiba. It proves that Hiba is governed by strict, legally binding conditions of offer, acceptance, and delivery, perfectly mirroring civil contractual obligations. When you write this on your exam, I want you to draw a neat, highly visible box around Abdul Qadir versus Salima to ensure the examiner sees it the second they turn the page.
Second case, Bishan Singh v. Kazan Singh. Here, the court held that the right of preemption is a weak right and must be strictly complied with. Read that exact verdict again in your minds. Command yourselves to underline this case name on your paper. The background facts of this case involved a complex dispute over a preemption claim, where the court had to fundamentally decide the exact legal nature of the right itself. The final verdict confirmed unequivocally that Shufa is indeed a weak, easily defeated right. This perfectly reinforces our earlier point about the nature of Shufa. The relevance here is absolute. Because it is a weak right, the preemptor must perfectly align with every single legal technicality. One slip-up, one procedural defect in the talabs, and the court will strike the entire claim down. Underline Bishan Singh v. Kazan Singh to immediately capture the KSLU evaluator's attention for those full 16 marks.
Finally, number 5. Conclusion. Do not just trail off at the end of your paper. A strong legal answer always requires a definitive closing. You must summarize your legal arguments cleanly. Your conclusion reads, Hiba and Wakf differ fundamentally in purpose, ownership, and permanence. Pre-emption acts as a protective right. Together, they form important aspects of Muslim property law. This ties everything together in a neat professional bow. Class, mark my words, if you master this precise structure, if you present the definitions accurately, draw the difference table meticulously, assert the weak nature of Shufa, list the exact hierarchy of claimants, and proudly box those 2 landmark case laws, the examiner will have absolutely no choice but to award you exceptional marks. Mastering this rigorous blueprint is exactly what guarantees your success in the KSLU examination hall. Class dismissed. Study hard.